Welcome to the definitive breakdown of Indian democracy. In this series, we unpack Part 3 of the Indian Constitution, stretching from Article 12 to 35. This isn't just a legal text, it is the ultimate citizen's shield, forged to protect individual liberties against arbitrary power. To understand its foundation, we look back to 1791. Our constitutional makers drew direct inspiration from the United States Bill of Rights, adapting those global principles to secure the core liberties of a diverse India. Let's dissect the core DNA of these rights through four fundamental pillars. First, they are universal, guaranteed to all citizens equitably, without any room for discrimination. Second, they are primarily negative in nature. This means they are explicitly designed to place strict limitations and restrictions on the sweeping authority of the state, drawing a line it cannot cross. Third, they are strictly justiciable. If these rights are ever breached, they are legally enforceable in a court of law. Citizens hold the power to stand directly before the judiciary and demand their immediate restoration. Finally, their core political objective is clear: to establish and sustain a robust political democracy across the nation, ensuring that a government of laws always prevails over a government of men. Next, we look at the structural machinery that protects these rights. Articles 12 and 13. Article 12 maps out the perimeter of the state. It defines exactly who you can hold accountable if your rights are violated. It includes four main pillars: the Union Executive and Parliament, the state executives and legislatures, local bodies like panchayats and municipalities, and other authorities, which covers public undertakings and state-funded institutes. Once an entity is labeled as the state, it is strictly bound by the rules of fundamental rights. But what happens when a law tries to break through this boundary? Enter Article 13, the ultimate filter of judicial review. It states that any law inconsistent with fundamental rights will be declared void. To manage this, the courts use two vital doctrines. First is the doctrine of severability. If a new law clashes with your rights, the court doesn't kill the whole act. It surgically removes just the offending part, while the rest survives. Second is the doctrine of Eclipse. This applies to old, pre-constitutional laws. If they violate a fundamental right, they aren't completely dead, they are simply overshadowed and made dormant. If the Constitution is amended later to remove the conflict, the law can wake up and become active again. Now, let's explore the actual architecture of your freedom. The Constitution groups your fundamental rights into six main pillars. Pillar 1 is the right to equality, covering Articles 14 to 18. Pillar 2 is the right to freedom, spanning Articles 19 to 22. Pillar 3 is the right against exploitation, under Articles 23 and 24. Pillar 4 guarantees the right to freedom of religion, through Articles 25 to 28. Pillar 5 protects cultural and educational rights, found in Articles 29 and 30. And Pillar 6 is the right to constitutional remedies under Article 32, which allows you to protect all the others. But wait, why did we skip Article 31? Originally, there was a seventh pillar, the right to property under Article 31. However, it was completely removed from Part 3 by the 44th Amendment. Today, it is no longer a fundamental right, it is purely a legal right under Article 300A. Let's break down the first pillar, the right to equality, spanning Articles 14 to 18. Article 14 delivers a double layer of justice by mixing two distinct legal concepts. First, it guarantees equality before law, a British concept. It acts as a negative rule, stating that no single person is above the law and absolute privileges do not exist. Second, it promises the equal protection of laws, a positive concept borrowed from the US. This ensures equal treatment under equal circumstances, meaning the law can make reasonable classifications to help those in need. Following this foundation, the remaining articles apply equality to everyday society. Article 15 bans the state from discriminating against any citizen based strictly on religion, race, caste, sex, or place of birth. However, it leaves room for fair progress by allowing special provisions for women, children, and the economically weaker sections. Article 16 opens the doors of opportunity by guaranteeing equal access to public employment for all citizens. Article 17 is an absolute mandate. It completely abolishes untouchability, in any form, an offense strictly enforced by the Protection of Civil Rights Act of 1976. Finally, Article 18 checks societal vanity by abolishing noble titles, ensuring no citizen carries artificial royalty, though military and academic honors remain perfectly valid. Let's move to the second pillar, the right to freedom, centered around Articles 19 and 21. Article 19 guarantees 6 democratic freedoms, but none of them are absolute. Every freedom is anchored by specific restrictions to protect the nation. Freedom of speech and expression can be limited to protect sovereignty, public order, and decency. Peaceful assembly and forming associations are bound by public order and national integrity. Movement and residence across India can be restricted to protect the general public or scheduled tribes. And your choice of profession can be regulated by state licensing or monopolies. Now, let's look at how the judiciary transformed Article 21, the right to life and personal liberty. This evolution happened in two distinct eras. First was the narrow era during the Gopalan case of 1950. The Supreme Court followed the British model of procedure established by law. This meant the court could only protect you from arbitrary action by the executive branch. If the legislature passed a law to take away liberty, the court was strictly bound by the text and could not stop it. Everything changed in 1978 with the wide era during the landmark Maneka Gandhi Case. The court shifted to the American model of due process of law. Now, the judiciary reviews arbitrary legislative actions too. Any law taking away life or liberty must be fair, just, and reasonable. This massive shift allowed the courts to expand Article 21 to include the right to live with human dignity, the right to privacy, a clean environment, health, and a speedy trial. Later, the 86th Amendment of 2002 added a vital branch to this tree, Article 21A, making free and compulsory education a fundamental right for all children aged 6 to 14. While most people think fundamental rights only protect you from the government, the Constitution actually designs them to guard you on two completely different fronts. First, there is protection from the state. The vast majority of your rights, like Articles 14, 16, 19, 21, and 22, act exclusively as a shield against corporate or arbitrary abuse of power by the government apparatus. They ensure the state cannot silence your voice or take away your liberty without just cause. Second, the Constitution offers protection from private individuals. This is a crucial distinction. Certain rights act as a shield against fellow citizens, private groups, or societal systems. Article 15, Clause 2 guarantees that no private shop, hotel, public well, or restaurant can deny you entry based on your background. Article 17 absolutely abolishes untouchability, making it an absolute right with zero exceptions, whether practiced by the government or a private citizen. Article 23 strictly prohibits human trafficking, forced labor or bugger, and bonded labor by anyone. And Article 24 bans child labor under the age of 14 in all factories, mines, and hazardous industries. When it comes to religious freedom, the world uses two completely different models of secularism. Western secularism is a model of strict separation. The state and religion sit on opposite sides of a total wall. The government completely avoids any public display, funding, or support of religion. Indian secularism, however, operates on a principle of distance. The state remains neutral and impartial, but it stays engaged. It provides equal protection, respects all faiths, and maintains a positive relationship with every religion. This unique Indian model is powered by Articles 25 and 26. Article 25 protects the individual. It guarantees freedom of conscience and the equal right to freely profess, practice, and propagate your religion. Article 26 protects the group. It grants religious denominations the right to manage their own affairs, establish institutions, and own property. To qualify as a denomination, a group simply needs a common organization and a unique name. But remember, these rights are not absolute. The Constitution places clear, overarching restrictions on both articles. Your religious freedom can be restricted by the state to protect public order, morality, and health. Next, we look at how the Constitution preserves the vibrant diversity of India through Articles 29 and 30. Article 29 focuses on the protection of interests. It grants any section of citizens residing in India, who have a distinct language, script, or culture, the absolute right to conserve it. While this is usually thought of as a minority right, the Supreme Court clarified a major detail. Article 29 applies to both minorities and the majority community. Article 30 focuses on educational institutions. It gives minorities the specific right to establish and administer educational institutions of their choice. Here is the key insight to remember for your exams. The Indian Constitution explicitly recognizes two types of minorities, linguistic and religious. However, it deliberately leaves the actual term, minority, completely undefined anywhere in the constitutional text. Dr. B.R. Ambedkar called Article 32 the very heart and soul of the Constitution. Without it, all other fundamental rights would just be words on paper. It gives you the right to approach the Supreme Court directly if your rights are violated. To enforce these rights, the court issues 5 specific constitutional orders called writs. First is Habeas Corpus, which means to have the body of. It is issued when a person is illegally detained by the state or a private entity, ordering their immediate release. Second is Mandamus, meaning, we command. This orders a public official to perform a legal duty that they have failed or refused to do. Third is Prohibition, which means, to forbid. It is sent to a lower court to stop it from exceeding its jurisdiction during an ongoing hearing. Fourth is Certiorari, meaning, to be certified. This is issued after a lower court gives a verdict outside its authority, stepping in to squash that judgment and transfer the case upward. Fifth is quo warranto, meaning, by what authority. It investigates someone holding a public office unlawfully to prevent illegal takeovers of government positions. Finally, we look at the structural boundaries and how these rights survive a national crisis. The Constitution sets clear limits on the shield for specific groups. Under Article 33, Parliament can restrict the fundamental rights of the armed forces, police, and intelligence agencies to ensure strict discipline. Article 34 allows rights to be heavily restricted in any area where martial law, or military rule, is actively enforced to restore order. And Articles 31A, B, and C protect property reforms. This includes the famous 9th Schedule, created to shield specific laws from judicial review, and Article 31C, which elevates key directive principles over standard equality and freedom claims. But what happens during a national emergency? The state triggers 2 distinct legal switches. Switch 1 is Article 358. This switch is completely automatic. The moment a national emergency is declared due to war or external aggression, your Article 19 freedoms are instantly suspended. Switch 2 is Article 359. This requires a specific presidential order. It allows the president to actively suspend your right to approach the courts to enforce other specific fundamental rights. However, there is an unbreakable core. The 44th Amendment guarantees that no matter how severe the emergency is, Articles 20 and 21 can never be suspended. Your protection against double jeopardy and your absolute right to life and personal liberty remain completely untouchable. We conclude with the ultimate question: how do fundamental rights interact with the rest of the Constitution? First, consider the relationship between fundamental rights in Part 3 and directive principles in Part A. Fundamental rights act as negative injunctions on the state to protect individual liberties and establish a political democracy. Directive principles are positive obligations meant to guide the state toward a socio-economic democracy for the community. For years, a legal battle raged over which side takes precedence. The ultimate resolution came in the landmark Minerva Mills case of 1980. The Supreme Court ruled that they are not contradictory, but complementary. The court used the metaphor of a chariot. Part 3 and Part A are like its 2 wheels. They must exist in a harmonious balance to move the nation forward. But can Parliament amend and alter your rights? The journey to answering this defines modern Indian law. In 1967, during the Gopalan case, the Supreme Court ruled that fundamental rights are completely immutable, meaning Parliament cannot touch them. In 1971, Parliament retaliated with the 24th Amendment, passing a law that gave itself absolute power to amend or destroy any part of the Constitution, including rights. This climaxed in 1973 with the historic Kesavananda Bharati case. The court delivered the definitive basic structure doctrine. It ruled that Parliament holds the power to amend any part of the Constitution, including fundamental rights, but it can never alter or destroy its core foundational pillars, like judicial review, secularism, and the rule of law. The citizen's shield can be reshaped to fit changing times, but its core can never be shattered.